Hello, my name is Brant Hunt, and I'm going to be reading another chapter tonight called the book called The Rape of Justice by Eustace Mullins. This will be chapter 4 tonight. Hopefully, we'll get through it. We'll see how long it will take. It's getting late here, but I wanted to basically um, get into this book here. I have many books that I like to read. I also have many books that I want to share with other people. And it's also a way of educating people uh, for those who don't have money. And a lot of times, not a lot of time. So my name again is Brant Hunt. My channel, Discerning What Is True. I'm on Facebook. That is with my name, Brant Hunt. I'm also on Odyssey and on YouTube. And what I'm going to be doing is reading from this particular book, The Rape of Justice by Eustace Mullins, who I consider one of the best writers. Deals with this type of issues, many issues he deals with. He's written many books, in fact. I don't even have all these books, to be quite honest with you. So this is chapter 4, and let's get into it, okay? Thank you for being here. Today is now the 5th day of March, that is 2023. So this is, again, from a book called Rape of Justice, and the chapter is Judge Not. And let me get to where I need to get into so it'll be better for me, so you can understand me a little bit better. Okay. The origin of the word judge is found in Juden, that is Juden, or in Spanish, Juez, Juez. In the United States, the judge sees himself, first of all, as the guardian of the present legal system, while carefully cultivating his public image as the epitome of impartiality. Let's go a little larger here, so it'll be easier. He succeeds in letting interest inquiries know that his impartiality may be swayed by certain considerations. For this reason, it is crucial that a citizen entering an American court as a litigant should discard the assiduous, cultivated myth of judicial impartiality. If you are a farmer, a small business operator, or a wage earner in any type of business, you are already beyond the pale. As far as the judge is concerned, you have been consigned to the never, never land of the hoi polloi. The judge will not let anyone leave his court without being convinced that he is the elitist. You've been told too many stories in your schools, folks. You've been told too many these great things that really are not true because we haven't experienced them, you see. It's a fairy tale. During a national campaign to increase judges' salaries in 1989, it was found that judges whose salaries ranged from $89,500 to $115,000 a year reported average extra income from $16,624 to $39,500. Most that's pretty good money back in 1989. The Associated Press survey found that the median 1987 income for a federal judge was from $108,000 to $130,000. In pleading for the pay raise, Robert Williams of the 10th U.S. Circuit, that is CT, in Colorado, stated that judges' salaries, rather than being geared to the income of the average taxpayer, should be geared to the average of practicing lawyers. However, the Associated Press survey shows that the median income for American 707,000 lawyers and judges was only about $45,000. That's including with the census report. McWilliams apparently was unaware that judges' median income was already more than double the median income for American lawyers. So the demand for ever higher salaries is part of the judge's elitist drive, you see. Judge has attended the university. His family has sufficient funds for him to go on to graduate law school and to become a professional man, and later become a judge because he attracted the favorable attention of even more powerful elites who concluded that he would serve to protect their interests, not your interests, their interests in the courts. The judge resides in the upper income suburb. owning a home of considerable value in the area of other elitists. He belongs to a country club whose members are strictly limited to elitists. He maintains unadvertised affiliations in one or more religions, fraternities, or political groups. Preeminence among such groups is the Masonic Fraternity Organization. The majority of Masonic members never go beyond the 3 degrees of the Blue Lodge. They are never informed that the higher degrees are forbidden, under pain of death, that is, to disclose any of the manifestations of the higher degrees to any member of the Blue Lodge. This does not mean that members of the Blue Lodge reap no advantages from their membership. On the contrary, they continue to receive favorable treatment in the banks, in the courts, and from other businessmen. The courts are preponderant extensions of the Masonic Brotherhood. Most lawyers and judges are fellow lodge members. Preferably treatment is extended to all members of the Brotherhood who come before the before the court. In our largest cities, most judges are also Zionist collaborations. If inactive Zionists, they have been screened by Zionist organizations and have been found satisfactory. I'm going to add a part here because I kind of think it's important. Almost all your secret organizations, you know, like the Masons, the Jesuits, all these people are actually, as far as I can tell, this is my opinion, not what Eustace Monin says, they're a Jewish background. They worked in that way. That's why they're basically a secret societies. Think about that, okay? A judge is almost always a member in good standings for one of the major political parties. He's almost never a member of an independent political movement. He's usually a member of an established church that is either Protestant, usually Episcopalian, although more than half of judges in the United States are Roman Catholic. He may even belong to some extremist organization. The Supreme Court Justice Hugo Black had long been a member of the good standing of the Ku Klux Klan after he had been appointed to the Supreme Court by President Franklin Delano Roosevelt. Black admitted his Klan membership. The leak had come from a communist ideology during the heyday of the capture of the National Democratic Party by the fanatic Stalinist wing of the Communist Party. Klan membership was anathema to these ideologies. Only Nazi affiliation carries a greater stigma. Black humbly promised never to go to another Klan meeting and served on the court for many years. Political realists in Washington knew that the Black's political career had been built on his Klan membership in Alabama. Without it, he could not have been elected to the Senate. Once in Washington, he became a loyal supporter of FDR's most socialist policies and was rewarded by the Supreme Court appointments. With the Klan affiliation hanging over his head, Black became an ardent supporter of every violation of the Constitution as a member of FDR's court. The Black episode illustrates the necessity of a judge having powerful political support. Conversely, he need know little or nothing about legal problems or the actual practice of law. He's expected to show unwavering loyalty to the prevalent party line during his service as a judge. Those judges who at some point begin to believe that they are a power in themselves and who substitute their personal views for the exigencies of the current party line, which varies from day to day, as any practical political stance must do, are the judges whom you read about in the press. They are judges who are impeached for high crimes and misdemeanors, stripped of their office, that is, and sent to prison. This is a very rare occurrence, and the sitting judge is never allowed to forget where his real allegiance lie. The judge exercises supreme power over the parties who stand before him in civil litigation or in criminal actions. He has equal power over the lawyers who stand before him, and he never allows anyone to forget that power. In this regard, the judge is not actually an employee of the city, state, or nation which pays his salary. He is the tool of the secret entities who control all aspects of American life from behind the scenes. The servile press, that is, has made it fashionable to sneer anyone who speaks of a conspiracy, with the implication that anyone who believes there are conspirators is probably mentally ill and should be excluded for the safety of society. Bullshit. We are often reminded that persons who claim to have some knowledge of the inner workings of the conspiracy have been promptly spirited off to asylum, where the continuous administration of mind-altering drugs soon convinces him that he was mistaken in his charges. The agitator, that is soon reduced to a helpless, drooling inmate who, whenever he shows signs of recovering his wits, he is immediately given a stronger dose of Thorazine, by the KGB, that is. Fallacy of judicial impartiality can be denied by any practical attorney. In our largest cities, the practice of judge shopping among scheduled members of the bench is a daily occurrence. A lawyer will use any stratagem, not the least of which is the employment of carefully cultivated relationships with clerks of the court to have a case moved from a judge known to be hostile either to the defendant or to the type of crime he has committed or to the lawyer himself. Throughout the legal profession, it's common knowledge that most judges with years of service on the bench are always, almost universally hostile to anyone who comes into court without an attorney and declares his intentions of representing himself. Judges are also very hostile to women lawyers and to blacks and other minorities. Judge Susan M. Skinner of Lee County, Florida, recently resigned her judgeship, citing sexism and petty politics in the judicial system as reason for resigning the judgeship she had held since 1984. She made her letter of resignation public, stating that I have come to the conclusion that there is more to life than remaining as a part of this judicial system. I cannot envision myself emulating a number of the present judges with their infighting, envy, and dispassionate processing of their cases, nor can I further tolerate the total domination our current court administration is allowed to exercise over the judicial. This is based upon this is from Fort Myers, Florida, News Press, June 16, 1989. Judge Skinner has caused a community uproar when she learned that a defendant had AIDS. She ordered him from her courtroom, saying that she was insulted by his audacity in appearing in court, and she feared he would spread the disease to others in the courtroom. A national public outcry was raised by the powerful homosexual community, and she realized that she would no longer be able to carry out her judicial duties in an atmosphere of harassment and intimidation. Liberal elements in Washington sought to replace the older members of the judicial with blacks and women, a process hastened by President Jimmy Carter, who replaced some 300 members of the federal judicial. Some of them have since been indicted, while others have resigned. In 1717, Bishop Benjamin Hoadley, Hoadley, informed the King of England, whoever had an absolute authority to interpret any written laws is truly the lawgiver to all intents and purposes, and not the person who wrote them. Thus, it is the judge rather than the person who wrote the laws, you see, who has been transformed from an impartial referee of the statutes and the creation of the statute. Judges are now handling our excessive punishments with little or no restraint on their decisions. The Wall Street Journal noted April 28, 1989, that the federal judge Richard Owen had given some defendants 100 years in a criminal case and 15 years in a tax fraud case, which was at least 5 times more severe than most attorneys thought appropriate. A federal judge ruled June 5, 1980, that the city of Parma, P-A-R-M-A, Ohio, must provide 300 units of low-income housing annually. This was described as the first federal takeover of a city. The D.C. Court of Appeals ruled May 10, 1989, that the District of Columbia Superior Court Judge Tim C. Murphy should have withdrawn from assault case which had been brought by a federal prosecutor, because at that very time he was applying for a position with the Department of Justice. It was ruled a clear-cut violation of ethical rules, although Judge Murphy defended his actions by pointing out that I taught judicial ethics for years. The overwhelming power of the judge in the American legal system has increased inversely to the decline of constitutional guarantees of individual rights and the concurrent rise of equity law. Equity originated from the Latin aequitas, meaning equality of justice. Equity is defined by Sir Henry Maine in ancient law as any body of rules existing besides the existing original or civil law, founded on distinct principles, and claiming incidentally to succeed the civil laws in virtue of superior sanctity inherent in those principles stemming from practical edicts. This is a reference to the annual proclamation of administrative law, which was added to each year by the Proctor, who correspond to the Lord High Counselor in English law. Equity jurisdiction had been established in England by the reign of Edward III. Equity had exclusively jurisdiction where it recognized rights unknown to common law, such as trusts. Equity had concurrent jurisdiction where the law recognized a right but did not give adequate relief, and auxiliary jurisdiction when the machinery of the courts of law was unable to procure the new evidence. Maine, that is spelled M-A-I-N-E, goes on to deplore the evils of this double system of judicatia. This present writer found early on that when his opponents realized that they could not destroy him in the civil courts, they moved to have the case heard in the equity or chancellor courts. At first, I was mystified by this move, although I was soon convinced of its purpose. I doggedly hung on and was finally able to settle the case on my own terms. The existence of this double system of judicatia is a powerful secret weapon which both judges and lawyers use against the public, giving them a decisive tactic which they can deploy just when the citizen believes that at last he will finally receive justice in the court. The abuses of our legal system are the most ironic when we learn that the traditional meanings of the scales of justice is that all things should be in harmony, weighed and established at an equilibrium between warring opponents. Libra, the sign of the scales, is the seventh sign of the zodiac and is ruled by Venus. Its jewel is the emerald, which represents the divine blend of colors, the blue of heaven with the gold of the sun. In Terra, the justice card is represented by a seated and crowned Lord, who is in the enthronement of the imperial dispenser of justice, according to King Solomon. The destination of the scales of the signs of justice was intended to decree that all worlds and all forms of human nature should attain a balance. In practice, this idea has not been achieved. The scales of justice, rather than weighing the evidence presented by the opposing forces until preponderancy occurs on one side of the order or the other, allow the adversary system to force the scales down on one side, justifying decision in favor of that party. Thus, the idea of balance has been abandoned, not only because of the adversary system, but also because the scales of justice, instead of signifying harmony, has been converted into the scales of commerce, in which commodities are weighed to determine their price before thy sale. Part of this to do with, if I understand simply, is I'm just going to elaborate a little bit here. It has nothing to do with the law of the land anymore. It's become the law of the sea. And what he's talking about here, I don't know if he recognizes it or not, but he's talking about commerce. And commerce is the law of the sea. It's the law of the merchant. Okay? And this change took place in the 1700s. I think it's 1766. I think it's correct. Or 1707. Maybe 1707. Don't follow me, but it's sometime in the 1700s. And so what happened was simply is our courts have gradually changed from looking at what we call the law of the land to gradually what we call the law of commerce or the law of the sea. You see, this occurred in England before it occurred here. Let's see so equity law was a tremendous move in this direction, allowing first the amicable courts, that's right, and then the law merchant to supersede the common law, and in the United States, our constitutional law. In the law merchant, all law is concerned merely with the handling of economic disputes, and the scales of justice have become the scales of the trader or the broker. Because of this development, the office of judge itself becomes an item of trade to be auctioned off to the highest bidder. Just as the scales of justice are used to weigh the relative power, influence, and finances of the parties, so the judicial robe becomes a sellable property, you see. Although it is still offered in outlying areas of the nation as a bid for those who hold the reins of power in the largest cities, it has been reduced to the sole element of price. This can be verified in our most reputable, publications such as the New York Times on October 2nd, 1988. This newspaper featured a lengthy interview with Matthew Troy, who was formerly a pillar of the system as a New York City councilman and a Queens Democratic Party leader. They served short period prison sentences in 1980. after pleading guilty for filing false income tax returns. He now lectures at universities on the realities of our judicial and political system. Troy says that the public has the idea that politicians are crooked, and usually they are right. He states that he swapped state assembly votes for judgeships, that visitors come to his office with briefcases bulging with cash, and that he routinely turned down bribes from reporters and developers. One reporter offered to run favorable newspaper stories about him for a mere $500 a week. Troy's most important revelation is a recounting of the current price list for the purchase of a judgeship. The usual price for a judgeship of the Supreme Court of New York was $75,000, with lower court posts going for $15,000. That was common knowledge that I grew up with. He continues, a man comes to see me and he puts a briefcase on my desk, loaded, absolutely loaded with cash. And he says to me, "I'd like to be a judge." I asked him, "Are you a lawyer?" Although money remains the ruling factor, the guiding principle of the legal system remains an allegiance to the Masonic order. In many areas, the long bench is merely a chapter of the Masonic Lodge. Because of the great secrecy maintained by the lodges, no accurate figures can be given as to the number of American lawyers and judges who are members of the Masonic Lodge. Of the current total of 707,000 American judges and lawyers, it seems a good estimate that at least 500,000 are lodge members. It could be as high as 90%. Figures have been estimated for England in Stephen Knight's best-selling book called The Brotherhood. Shortly after publishing this book, which immediately became a bestseller, Knight, who was a young man, died suddenly. In other words, he found out the truth, and no one wanted to hear that, especially those at higher ups. We have despicable people, folks. We really do. Interesting persons have been unable to obtain any details of his death. Knight states that the Law Society, the English equivalent of our Bar Association, is one of the most Masonic institutions in the world. 90% of its members are Masons. He points out that this situation itself creates grave inequalities. I should say grave inequalities, because the Law Society is a final arbiter as to who will receive legal aid and who will be denied it. In practice, a non-Mason has no chance of receiving legal aid in a suit against a Mason. Knight says that 50 to 70% of all English judges are Masons. This figure is probably close to that in the United States also. Lawyers soon become aware that if they expect to have any clients, if they wish to win cases in court, they must join the Masons, because most of their client referrals will come from the source. Knight cites the Unlawful Society Acts of 1799, requiring that secret societies could hold meetings only if the names of their members were submitted to the local clerks of the peace. He notes that although this law has been on the books for almost 2 centuries, the Freemasons have never complied with it. However, he failed to consult the text of the Act, which specifically exempts the Freemasons, because the English royal family was and continues to be the official patron of English Freemasonry. The lodges were brought to England in 1717 as the result of conspiracy of many years, which placed the Hanover family on the throne of England. They have been consistently active in and faithful to their Masonic origins ever since that date. Americans who become involved in the legal mazes of our courts are often astonished by the strange decisions which are handed down by the judges. In nearly every instance, the strange outcomes of the case can be explained by the omnipresence of Masonic influence. Thus, citizens have no way of knowing that they have been subjected to the errant assumptions of an Oriental disposition, masquerading under color of law. How can genuine justice be administered if the judge has taken an oath under penalty of death that he must always rule in favor of his brother Masons? The Masonic Handbook command is as follows, page 183 to 184, stating, whenever you see any of our signs made by a brother Mason, especially the grand hailing sign of distress, you must always be sure to obey them, even at the risk of your own life. If you are on a jury and the defendant is a Mason and makes the grand hailing sign, you must obey it. You must disagree with your brother's jurors. if necessary, but you must be sure not to bring the Masons in as guilty, or that would bring disgrace upon our order. The handbook continues, though, stating you must conceal all crimes of your brother Masons also, except murder and treason, and these only at your own option. And should you be summoned as a witness against a brother Mason, be always sure to shield him, prevaricate, don't tell the truth in this case. Keep his secrets, forget the important points. It may be perjury to do this, it is true, but you are keeping your obligation. So see who's putting themselves up above the pretty poor here. It is also important to note that the use of the word obligations is a key ingredient of the Masonic Code. Most persons are referring to a moral problem would use the word duty, as the founders of our republic would say. However, a Mason is certain to use the word obligation as a code warning to other Masons who may be present that they are now under an overriding order to carry out their obligation to their brotherhood. This obligation means that he must commit perjury in court. He must rule as a jury member in favor of a brother Mason, despite any evidence presented against him. And as a judge, he must rule for the Mason. As a clerk of the court or any other court official, he is obligated to alter, steal, or destroy any official public records or documents which might compromise a brother Mason. This writer has frequently sent written complaints against Masonic judges and lawyers to U.S. attorneys. In every instance, the Department of Justice has replied to the document charges of blackmail, theft, and extortion. You should hire a private attorney, meaning that you must find yourself a Masonic attorney and hope that he will handle your case against his brother Masons. The Masonic Handbook further commands that if you cheat, wrong, or defraud any other society or individual, it is entirely your business. If you cheat government even, Masons cannot and will not touch you, but be very careful not to cheat, wrong, or defraud a brother Mason or lodge. Whoever else you may defraud, live up to your Masonic obligations. So you see which group is ahead of the other type. It is impossible for anyone to understand the depths of such depravity unless one understands the very origins of Masonic brotherhoods. See The Curse of Canaan by Eustace Mullins. And morality is dictated by the basic authority, the will of Canon. The 5 things did Canon charge his sons: love one another of the tribe, love robbery, love lewdness, hate your master, and do not speak the truth. Canaan has lived out his entire earthly existence under the curse of Canaan, that is, a sentence of slavery which was fastened unto all of his descendants. The command to love one another referred only to those direct descendants. It also gave the implied commandments that they were to hate all other occupants of the earth. They were further commanded to seek out their living by committing robbery, by promoting sexual vice, through love of lewdness, and to hate their masters because they had been condemned to live on earth as slaves. Finally, they were not to speak the truth, a command which launched the tidal wave of perjury which has now inundated our courts. The fact that Masonry stems from biblical times is shown by its secret password, Tubal Cain, T-U-B-A-L, Cain, which memorializes, that is, the line of Cain. Cain committed the first murder on earth when he slew his brother Abel. Cain's descendants, that is, Nimrod and demonic power, became the first ruler of the world. His reign was marked by sex orgies and child sacrifices, outrages which caused Shem, the son of Noah, to behead him and to cut his body to pieces as a warning to other malefactors, that is. These pieces were sent to Nimrod's priests as a warning to desist from their vile practices and demonic orgies. Instead, the priests treasured the remains as objects of worship. They were concealed in groves in rural areas as the shrines of the first mysteries. That is, Albert Pike, the theoretician of the Masonic movement, notes in his definite works, Morals and Dogmas, that all Masonic rites originated in these mysteries. The priests became the Gnostics, you see, the knowing ones, that is, those who knew where the body or the relics of Nimrod were hidden in the groves. Throughout history, these relics, or later copies, have persisted as the symbols of the Canaanite resolve to hate your masters and destroy them in such orgies as the French Revolution and the Communist Revolution. Their final objective is to seize by force all the riches of the world and return them to the rebuilt temple of King Solomon. Although perjury and abuse of the legal system remain crucially elements of the Masonic drive for control of the world. Murder or assassination continue to be the final symbol of their operations. Thus, a citizen of the United States has no idea when he enters the American court that he is now entering an arena in which federally conspiracy is the dominant factor, where perjury and assassination are considered to be routine matters. You see, methods, I should say, of the operation. It could be informed in this reality. He would be able to cite numerous precedents denying the judge qualifications on the grounds of bias. Equal protection of all is a basic principle on which rests judges under the law, based upon Pierre, P-I-E-R-R-E-R versus State of L-N. I assume that's Louisiana, but I don't know. That's the only one that's got an L in it. 59 SCT 536, 306 US 354, 83 LED 757. Perjury of or bias on the part of the trial judge may constitute a denial of equal protection of the law. Osborne versus Verdome, 250 S.W.2D159. In a trial situation, the judge faces two imperatives. First, he must conceal the existence of his Masonic allegiance. Second, he must impose by imperial decree his commands upon all who come before his court. There are many decisions which reflect these imperatives, such as U.S. Judge Thomas McBride's decision in case number 9909, May 2nd, 1967, under the Lord Coates ruling of 1608 and Peter versus the Crown, that no officer of the Crown could be charged with a crime, even if he were guilty. Judge M.L. Swartz, S-C-H-W-A-R-T-Z, dismissed case 83-699-MLS, April 11, 1984, under the Magna Carta of 215, that we had no right to file charges against public officials or members of the bar because the Constitution of the United States did not apply in the jurisdiction of the federal courts. Judge R.A. Ramirez dismissed case number 84-03-0503, RRAR, July 23, 1984, under Bell versus Hood, which was also based on Lord Coates' ruling of 1608, citing the Magna Carta stand that persons of a lower class caste cannot present charges against members of the of the title peerage class. These rulings in our federal court, that's right, folks, that's what the Magna Carta says. These rulings in our federal courts ignore the first statute ever passed by the U.S. Congress in its first section, 1791. This statute concerns the punishment of judges and other public officials who fail to enforce the law. The statute commanded that the people be guaranteed the citizens' rights. The failure to do so was termed insurrection. Sidney Smith, in his fallacies of anti-reformers, noted that if the law be good, it will support itself. If bad, it should not be supported by irrevocable theory, which is never resorted to but as the veil of abuses. All living men must possess the supreme power over their own happiness at every particular period. When a law is considered immutable, instead of being repealed, it is chronologically avoided or openly violated, and thus the authority of the law is weakened. And this is what's so critical when I go back to the missing 13th Amendment. It was basically to prevent men who were a part of the system, lawyers. And once that door opened up, all this is this is why it's so imperative for people to understand. Just because something, a little thing happens, doesn't mean it's just going to be like that forever. It multiplies, it gets worse. You see how that works? Sir Francis Bacon noted in his Judicator, judges ought to remember that their office is just discert and not just there. That is J-U-S, dare, to interpret law and not to make law or to give law. Judicially, official, es rest in tempora rerum. A judge must have regard to the time as well as to the matter. Ralph Waldo Emerson in Worship states that we owe to the Hindus a definition of law which compares well with any of the Western books. Law it is, which is without name or color or hands or feet, which is the smallest of the least, or the largest of the large, all knowing all things, which hears without ears, sees without eyes, moves without feet, and seizes without hands. Of Emerson's definition, the one most readily applicable in experience with our court system is that it does indeed seize without hands. Seizure is always its prime moving force. Adam Smith notes in his Wealth of Nations, justice, however, was never in reality administrative gratuitous in any country. In order to increase their payment, the attorneys and clerks have contrived to multiply words beyond all necessity and to corrupt the law with language. Robert Ringer notes in his Looking Out for Number One, the practical consequences of government are that it uses the threat of violence either to force you to stop doing something you want to do, or force you to do something you don't want to do, or to force you to give up something that is rightfully yours. Daniel Webster stated in March 10, 1831 in New York City, the judicial power comes home to every man. If the legislature passes incorrect or unjust general laws, its members bear the evil as well as others. But judicatia acts on individuals. It touches every private right, every private interest, and almost every private feeling. What we possess is hardly fit to be called our own, unless we feel secure in its possession. And this security, this perfect system, cannot exist under a wicked or even a weak and ignorant administration of the laws. There is no happiness. There is no liberty. There is no enjoyment of life unless a man can say when he rises in the morning, I shall be subject to the decisions of no unjust judge today. In retrospect, when Daniel Webster made this statement, the powers of the judiciary were almost non-existent compared to the powers which they exercise today. What would he say if he were now alive and confronted with the dictatorial powers which the judicial system has assumed over every aspect of American life? We have seen the seizure of the schools, the decision as to how our earnings shall be spent, which sort of neighborhoods we are to live in, and the judicial system on which the government agencies depend to enforce their decrees. A defense filed by Alan Stewart in Arkansas on July 3rd, 1978, noted that a hearsay substitute had filed a complaint against him in violation of the United States Constitution, and that hearsay substitute was his accuser, whereas he had the right to face his accuser. Stewart pointed out that the district attorney served both as an officer of the court under the judicial, as a law enforcement officer under the executive department, which placed him in flagrant violation of the doctrines of separation of powers in meeting, a system of checks and balances of the Constitution. Stewart also pointed out that the title officer of the court is officer of the court is an unconstitutional title of nobility, that all lawyers are automatically a part of the judicial branch of the government, whether elected, hired, or appointed. Article 1, Section 9 and 10 forbid titles of nobility. That's a key point, folks. That's what the amendment was about, but even he's pointing out something here I have not heard of, so I need to look this up in the Constitution. With the hearsay substitute being a lawyer and the judge also a lawyer, a conflict of interest exists by having lawyers or officers of the court representing both sides, you see. Stewart deposed that all lawyer judges have to disqualify themselves because of conflict of interest, which prevents them from presiding over a fair trial. This would seem to provide a useful alternate to the present abuses committed by judges who claim to be operating under due process of law. Dr. Felix Cohen wrote in the Columbia Law Review, June 1935, due process of law means nothing in the light of recent judicial decisions. That is metaphysical cover-up phrase, you see. Under a Ulysses justification of judicial tyranny is the much abused phrase, having your day in court, which means that merely by allowing you to set foot in his hollow precincts, the judge is giving you access to more justice than you are due. And upon extending this gracious privilege, the judge is then free to render whatever horrendous decision he pleases. Dr. Cohen continues, legal concepts, for example, that is corporations or property rights, are supernatural entities which do not have a verifiable existence except to the eyes of faith. Rules of law, which refer to these legal concepts, are not descriptions of empirical social facts, but are rather theorems in an individual system. Jurisprudence is a special branch of the science of transcendental nonsense. Thus, Dr. Cohen, who was labored for many years in the field of jurisprudence, comes to the inescapable conclusion that his lengthy experience has really been in the realms of fantasy land. Few Americans realize that while they are sitting in court listening to their paid counsel to defend them and interests, the judges are hard put to keep from grinning at the nonsense they are paid to listen to. As Alan Stuartstead, Stuardt, points out in his complaint, everyone and everything that is taking place in the court is hearsay and substitute, which is actually governed by abstruse concepts from the Kabbalah or from other mystical formulas which the citizen is never aware of. The present writer has heard much transcendental nonsense in our courts, precisely what Dr. Cohen describes, was finally able to define its origins in the curse of Canaan. As a modern day presentation of the ancient cult of Baal, as refined in the Kabbalah and the present statutes, it is not accidental that this transcendent nonsense is overseen by a judge who wears black robes. This itself is a legal terminology referred to the cult of the robe. Since man's beginning, the garb of justice has traditionally been white. We have never asked ourselves when and how the robes of justice suddenly became black. But at that moment, the rape of justice began. Instead of the color of unsullied purity, we now have the black robe as the sign of Babylonian justice. The Canaanite precepts originated by Nimrod, presented against the backdrop of the sexual orgies and the madness of child sacrifice, which were the hallmarks of the religious rites of Baal and Ashtoreth. However, we must admit that there is no attempt to deceive anyone. The judge appears before us in his robe of Babylonian black as the high priest of the rites of Nimrod. It is we who offer no objections, you see, or ask to judge whatever become of his white robe. The dome of the courthouse itself is another symbol of Babylonian law. It's purposely designed to confirm that we are now entering the jurisdiction of Babylonian justice, which is inflicted upon us by a Byzantine maze of secret intrigue and worldwide conspiracies. The character of those who put on the black robe is amply documented by public records. Time magazine reported July 18, 1977, on the exploits of Associate Judge Yarborough of the Texas Supreme Court. Yarborough was making a statement about a man who had testified against him. I want Kemp wiped away. The best thing would be to do it myself if I had a gun and a silencer. Yarborough was referring to a 1974 fraud scheme in which Kemp had testified against Yarborough and his associate John Rockoff after they had received a $30,000 payment for a collection of rare coins, which they never delivered. Yarborough then used his judicial position to obtain forged papers and a new identity for Rockoff, who hid out as a fugitive in Louisiana and Texas for several years. Yarborough was subsequently indicted by Austin, Texas grand jury for soliciting murder, forgery, obstruction of justice, and perjury. The Texas Supreme Court has been much in the news for the procedure by which its members are chosen. They campaign like any other politician for election to office and must spend millions of dollars on their campaigns. Traditionally, most of their campaign funds are provided as donations from the Texas Trial Lawyers Association, with individual lawyers contributing as much as $25,000 to the campaign of a single candidate. I didn't even know this, folks. This is weird. Chief Justice Thomas Phillips, although running unopposed, managed to raise $1.1 million campaign funds from some 4,500 donors. The record-breaking $10.5 billion judgment which Pennzoil won against Texaco was followed by public consternation when it was revealed that the lawyers who represent Pennzoil had contributed more than $355,000 to the non-Texas Supreme Court justice from 1984 to 1987. In 3 years, folks, they gave over $350,000 to non-judges. Preceding the announcement by the court that it would refuse a hearing to review the $10.5 billion judgment against Texaco. 3 of the justices then resigned from the court, although a present candidate for the court had also raised $1.1 million in campaign funds, nearly all of it donated by lawyers who would subsequently argue cases before the same judge if he could win the election. If not, they would argue before another judge to whom they have also contributed substantial amounts in campaign funds. Since the end of World War II, there has been increasing public criticism of judges for abuse of power, corruption, and the arbitrary decisions, but little has occurred which improves the situation because they can't be touched. That's the sad part. They can't be touched. The secret of the dirty secret of the judicial is that their appointments always come from politicians, and that the moral and intellectual background neither the judges nor the politicians ever taken into consideration. Thus, President Harry Truman was described by poet Ezra Pound in the Cantos, Cantos. Truman was loyal to his kind, the underworld, that is. This was a direct quote from longtime Washington journalist Rex, R-E-X, Lampman, Lampman, whom I had taken to visit Pound. However, Pound was merely restating that most Americans already knew. Truman remained loyal throughout his career to boss Pendergast, Pendergast, who was sent to prison for a multi-million-dollar insurance scam. The New Republic noted March 10, 1952, that Truman's appointment of some 125 federal judges had weakened the federal judicial and lowered its prestige. The political handshake gained its greatest triumph when Tom Clark was appointed to the Supreme Court of the United States. Clark was described in the New Republic as an oil lobbyist from the Texas state legislature and a protege of Senator Tom Connally. In retrospect, the cronies whom Truman appointed to the federal bench probably were no worse than the dreary possession of legal hacks and lobbyists and war heroes and bondsmen who had been named to the bench by subsequently President Carter probably sank the prestige of the bench to a new low with his maiming of some 300 political actors from the ranks of feminists, minority class agitators, a club of lunatics which turned the federal courthouses into asylums. In Harper's, that is September 1934, Mitchell Dawson wrote, "Judging the Judges. His Honor and his confreres on the bench have authority to rule upon the rights, duties, and privileges and immunities of everybody and everything within their respective bailiwicks. The gravity of power and responsibility thus resides in the judicial are appalling. Dawson went on to comment upon the moral attributes of such power. He noted that the three judges were noted among the pallbearers of Big Jim Cosimo, the first of the big shots in the liquor trade and bootlegging. Big Jim was the protege of Edward G. Robertson's characteristic of the gangster, that is Rico, in his famous picture Little Caesar. Two judges and an ex-judge joined the cortege of city and state officials who followed the solid silver casket containing the body of Angelo Gina, the noted convict and killer. The Chicago Crime Commissioner said a certain municipal judge was familiarly known to the criminal trade as cash register. One magistrate was removed from office for accepting a loan of $19,600 from Arno Rothstein, the noted gambler. That's Rothstein. Evidence showed that the fixing of cases in the magistrates' courts was an established business. So much for judicial situation in 1934. American Law Journal noted in its issue of February 1988 that a Wisconsin trial court judge and the senior partner of the state's largest law firm, the 278 lawyer firm of Fowler and Larder, now face sanctions for holding ex parte discussions in the fall of 1986. As we have pointed out, discussions in which opposing lawyers and or judges hold secret conferences to discuss cases without the parties being present. Wow. Constitutes one of the gravest problems of a legal system which pits the lawyers against the rest of the citizen. In Texas, a judge was severely criticized because he had given a relatively light sentence to a criminal who shot two men. The judge responded with a surprise, but they were only queers. This brought a national protest from the powerful homosexual lobby. In Seattle, Judge Gary Little, judge of the King County Supreme Court, shot himself after learning that a Seattle newspaper planned to run an expose of his 20 years sexual abuse of male defendants who came before his court. The local media had deliberately suppressed the story for decades. The reporter finally admitted that he had opened the door of Little's office in the state attorney general office in 1968 and found Little kissing a blonde, blue-eyed male student. Tape accounts had been available for years from juveniles who complained that Little's had molested them while their cases were being deliberated in his courts. Some of them were invited to stay overnight in a Seattle home or at the weekend cottage on an island. We really do have some really despicable people, don't we? In New York, a sensational trial of former Miss America, Bess Meyerson, dragged on for weeks before her acquittal. Meyerson, who called herself the Queen of the Jews, and had faced sentences up to 30 years on charges of obstruction of justice, mail fraud, bribery-related charges, and conspiracy. She and her lover, a contractor, had involved Judge Hortense, Hortense, Gabel, Gavel, and her lover divorce proceedings. The chief witness against the judge was her own daughter, whom the press described as eccentric and suffering from depression. The political influence State Supreme Court of New York Justice Louis Fusco Jr., who was under investigation by the U.S. Attorney Rudolph W. Giuliani on an accusation that he had improperly directed business to an insurance company operated by a friend, announced that he would not seek renomination. But the president of the insurance company in question was known as a lifetime friend of the judge, whose nephew was named vice president of the company. Another prominent Bronx judge, former surrogate Bertram Goffin, was ousted last year for misconduct. On August 24, 1986, the Las Vegas Sun warned of the ominous implication that federal judges or any other citizen will remain a subject to malicious persecution or prosecution for merely speaking out against injustice. The matter under discussion was a malignant persecution of a federal judge, Henry Claiborne, which finally wound up before Congress. Congress then voted for his impeachment. What was behind this case? Nevada High Court had already rendered a decision, that is the State Bar of Nevada versus Claiborne, that is 756 P2D 464 1980, that Claiborne had been guilty of nothing more than mere negligence. Judge Claiborne, the bearer of a proud Southern name, had served with distinction in the U.S. Air Force during World War II, and later become one of the most respected defense lawyers in the West, devoting more than 30% of his time to pro bono without payment cases for the public good, probably a high percentage than any other lawyer in the United States. After being named to the judgeship, Claiborne continued to come down hard on the side of the public. He excoronated both FBI agents and IRS agents who brought cases before his court with fantastic, poorly prepared charges, which were usually based solely on information provided by their paid informers. In the paid informant business, if you don't come up with something damaging against the subject, you don't get paid. This provides a constant stimulus to the imagination. Department of Justice agents launched a concerted campaign to block Claiborne's nomination to the federal bench in September of 1978, but they failed in their objective. They then began a campaign to destroy him. Editorial in the Reno Gazette-Journal was quoted with approval by Justice Stephen, Steffen. The Justice Department and the FBI was so incensed at Judge Claiborne that the need for revenge blinded them to everything but one burning desire. The federal government could not rest after Claiborne denounced his strike force lawyers as rotten bastards and crooks and liars. It could not bear Claiborne's insinuations without retaliation. The retaliation of the foreign federal agents was balked when they could find no basis for bringing any charges against him. They were forced to dredge up one of the nation's sleaziest characters, that is Joe Conforte, the world's most famous brothel keeper. For 30 years, Conforte had operated the famous Mustang Ranch, which never had any Mustangs. In May 1976, a well-known Argentine boxer was shot and killed outside of Conforte's Mustang Ranch. 3 Reno Gazette-Journal editorial writers won Pulitzer Prize for their stories exposing Conforte's operations. In 1977, both he and his wife were indicted for income tax evasion. He then fled the country to escape tax jeopardy assessments of more than $26 million, as well as 2 lawsuits filed after the Argentina boxer's death. IRS agents realized that Joe Conforte would be the ideal vehicle to get Judge Claiborne. They offered him a deal to testify about alleged bribes to Judge Claiborne. In return, he would be allowed to return to the United States. All but $3.5 million of the $26 million assessment would be forgiven. He would be guaranteed that he served no more than 1 year in a country club type prison, and all other charges against him would be dismissed. It was an offer he could not refuse. The fact that the IRS agents would be willing to forgive over $22 million in overdue taxes proves that they are not serious about collecting taxes. It's much more important that they maintain the legal dictatorship over American citizens. Invoking Lenin's 1917 rule, that is Lenin, who I've done videos about the Soviet takeover of Russia, confiscation of all assets as punishment for concealing income. In effect, federal agents were paying Conforte more than $20 million in a conspiracy to commit perjury and to obstruct justice, standard procedure in our legal system. In fact, Conforte's testimony against Judge Claiborne was subsequently documented as being perjured. Nevertheless, Judge Claiborne was indicted, convicted, and impeached by Congress. He served a short prison term and is once again practicing law in the state of Nevada, despite threats from federal agents that they will get him again. The point has been made. The federal government has sent a message from the District of Columbia to judges in every state: cooperate with Washington or else. Establishment judges have been treated much more kindly in prosecution, notably Judge James M. Landis, Landis, a former law clerk to Supreme Court Justice Louis Brandeis, the leader of the Zionist movement, which most people don't know about. Landis later was named Dean of the Harvard Law School, the private preserve of Vienna's revolutionary Felix Frankfurter, another one. Landis became one of the original brain trusts in FDR's New Deal. He was named chairman of the Securities Exchange Commission and became the eminent guise of President John F. Kennedy. Like many prominent Washington officials, he did not bother to pay income taxes. As a member of our nomenclature, he saw no need to conform to the standards enforced against the presidents and the holy polloi. It was revealed that he had paid no income tax for the years from 56 through 1960. The press hastened to defend him as a longtime crusader for ethics in government. While being charged with 5 years delinquent in paying tax, he was also named correspondent in a Washington divorce suit. Landis pleaded guilty to the tax charges and paid back taxes of income of $410,000. In the Chicago court system, which was still in the hands of the remnants of the Capone mob, a sting operation netted 10 judges in a ring of some 60 officials who were convicted of corruption. A Cook County judge, Earl Strayhorn, was accused in 1974 of not filing federal income tax forms for 1966 through 1968, failing to declare $49,000 in income and failing to pay $26,000 in taxes and penalties. He resolved the charges with a bargain payment of $11,000. In Austin, Texas, an AP release dated November 6, 1988, noted that a Texas judge had been recommended by the State Commission on Judicial Conduct for allowing her child to run around her courtroom during proceedings. She also called litigants and others pure trash and threatened to shoot a lawyer. She finally left the bench crying and shouting threats at the attorney. She told one lawyer that she had a gun and that she could shoot 2 holes in his back before he could leave the courtroom. The commission sternly noted that the comments of Judge Anthony had not consistent with the temperament required of a member of the judicial. During the same period, that is in Mariposa County, California, District Attorney J. Bruce Eckerson was reported to have resigned under pressure of continual lawsuits and criminal allegation of corruption and misconduct. The councilor clerk in Rankin City, that is Mississippi, faced 9 counts of embezzlement, and Middleburg, Vermont County prosecutor Robert Andrews was charged $400 for kicking a man in the face. Meanwhile, Dr. Elizabeth Morgan piled up 21 months in jail after being jailed by District Court Supreme Justice Judge Herbert Dixon on contempt of court charges. Dixon is black. Dr. Morgan is white. Dixon has ordered him to turn over her 6-year-old daughter to Hillary to her ex-husband, whom Dr. Morgan claimed had been sexually abusing the child since she was 2. Testimony from doctors and psychiatrists that the child had been abused had been ruled inadmissible. Dr. Morgan has spent her time writing children's books and became engaged to a circuit court judge. One avenue open to Dr. Morgan would be habeas corpus. Kent's commentaries points out I-619. Every restraint upon a man's liberty is, in the eyes of the law, a imprisonment, whatever may be the place or whatever may be the matter in which the restraint is effected. Kent hardly expected that a woman could be locked up for almost 2 years without conviction. I'll say that again, folks. Every restraint upon a man's liberty is, in the eyes of the law, a imprisonment, whatever may be the place or whatever may be the matter in which the restraint is effected. It's a pretty serious deal, folks. That's a pretty pretty serious sentence there, and it's true. Corpus Juris Secundum 39A HC 159 states that a petitioner for habeas corpus has the right to represent himself in prosecuting the proceedings. The presence of the petitioner in court is not necessary to argue issues of law, but the presence of the petitioner is necessary where questions of fact are to be litigated. In the federal courts, habeas corpus provides a remedy for jurisdiction errors without limit of time. Dr. Morgan could cite CJS 39A, section 163. A person whose detention is illegal or a third person on his behalf generally may present an application of habeas corpus, since it is intended for all who may be deprived of their liberty without sufficient cause, and such persons having standing to question their detention or deprivation of other rights. The writ must be brought against the proper person, generally whoever has actual custody of the prisoner. The title is Petition for Writ of Habeas Corpus. The writ should state some reason for granting the writ, usually that adequate relief is unavailable for other courts or in the other forms government intrusion upon petitioner First Amendment right to political expression, invalidating the prosecution and resulting confinement. That petitioners, that is the Fifth Amendment right to due process, is denied by his confinement. Wherefore, your petitioner prays that the court issue a order that the respondent show cause why this petition should not be granted and the petitioner discharged, that the court set out in the order a return of 3 days, that the court set the matter down for hearing within 5 days after the return, that the court hear and determine this matter, and upon final hearing issue writ of habeas corpus and an order directing the respondents to discharge the petitioner from their custody. Because the law has established that any restraint is grounds for issuing of a writ of habeas corpus, not merely physical restraint or imprisonment of a petitioner, but any government oppression or restraint, is similar grounds for a writ of habeas corpus, the respondent name being the government agents who are responsible for such restraint. Thus, a writ of habeas corpus may be filed against any federal agent, whether IRS, FBI, BATF, CIA, or UN, who is imposing stress upon any citizen of this nation, whether it be extortion, intimidation, or threats against one's occupation or family members. Section 171B, CJS 39A states that the writ must be made before the proper inferior court or judge. Section 172B states that the writ must be issued or the court must show cause why it is not being issued. Section 179 states the writ of habeas corpus is paramount authority over all other writs. Idaho, that is in Redob 241 P2D, under a federal statute, state court proceedings pending proceedings in a federal court for a writ of habeas corpus will be null and void. Thus, a prisoner who applies for a writ of habeas corpus in federal court, in theory, can halt state court proceedings against him. The CJS 39A notes that habeas corpus is a prerogative common law writ of ancient origins directed to a person detaining another, commanding him to produce the body of the designated prisoner as a designated time and place to do, submit to, and receive whatever the court shall consider in that behalf is called a writ, and is a civil remedy. The term derives from the Latin, you have the body. CJS 41 notes that a person in prison for committing an act that does not constitute any offense may be released on habeas corpus. Hill versus Sanford, CCA GA 131 F2D 417. This also applies to a person detained under an unconstitutional or invalid statute or ordinance. This is grounds for a writ of habeas corpus. Thus, we find that any unconstitutional oppression or pressure against any American citizen is ground for a writ of habeas corpus, that is, an order to relieve such pressure and to cease and desist. Habeas corpus is enshrined in the Constitution, Article 9, and cannot be suspended for any reason. CJS 39A, Section 37 states, habeas corpus may be allowed where there has been a deprivation of fundamental or constitutional rights. It has been held that questions decided by court having jurisdiction thereof may not be considered in habeas corpus proceedings in another court, whether or not constitutional principles are involved. This is based upon the case Craig versus U.S. CCA CAL.89F, capital F2D 980. The CJS 39A, Section 39, the writ of habeas corpus is designed to give a person whose liberty is restrained an immediate hearing to determine the legality of the detention. Walker versus Wainwright, FLA 88, State Court, looks like, Supreme Court. No, I think it's SCT 962, 390 US 335, LED.2D 1215. Habeas corpus provides a prompt and speedy remedy or a justification of a person's right to liberation from legal restraint or to be freed on whatever society determines to be intolerable restraint. Blaine versus Rogers, D.C. 332 F.SUPP 989. Thus, the widespread impression that the writ of habeas corpus applies only to persons detained in prison is merely one application of the writ. It can and should be used to apply to every instance of illegal, unconstitutional oppression by any government agent against any American citizen, whatever society determines to be intolerable restraint. Note that it does not say whatever the court determines. The people have the final jurisdiction and determination in the matter of intolerable restraint, and they must exercise their jurisdiction to determine that restraint. It applies not only to the forcible and illegal detention of a person's body, but it also offers an immediate legal remedy for any undue restraint upon any citizen of the United States in its pursuit of life, liberty, and property. For the first time, our citizens now have a weapon which enables them to take action against any act of oppression by government agents or power-crazy federal officials, many of whom are secretly in the pay of foreign powers. Freedom now. This is the message which the writ of habeas corpus brings to us. If any federal, state, or local agent is acting to oppress you, now is the time to file a notice with the proper court, naming that person, the nature of the restraint, and requesting a writ of habeas corpus, which will free you from that restraint. If the judge responds to your plea by dismissing on the grounds that you are not actually being held in detention, you must refile the writ, stating the exact nature of the writ and noting that the statutes do not require that you are being held in actual physical detention. The writ may be issued upon receipt of any governmental order which restrains you from any legal action or which attempts to deprive you of your personal property. The income tax is functioned as the primary restraint upon all citizens of this nation because it sets up a primary lien upon all citizens of this nation because it is set up as a primary lien upon all of our income and personal property at the behest of the Federal Reserve System, which is the secondary lien upon all income and personal property in the United States. Thus, the writ may be filed against the IRS or against the Federal Reserve System, or both. Its ramifications may be extended to each and every restraint imposed upon us by King George and the Bank of England. The writ should state such and such, acting in his capacity of agent for such and such, has willfully and intentionally sought to deprive you of your constitutional liberties, and has thereby restrained you from exercising your privileges of citizenship of the United States of the states. The judge must then allow you to argue in his court the nature of your restraint. He must then decide if it is a restraint, which in the light of the facts presented would be difficult to deny. If so, he has no recourse but to grant you the writ of habeas corpus. The Genocide Convention, The Genocide Convention adopted by our Congress also offers opportunities for our citizens to seek relief under its provisions. For instance, the present writer was prevented from marrying or raising a family by the malicious acts of federal agents who continuously had me discharged from gainful employment, thus effectively ending my line, and further sought to have me detained in an insane asylum, which they were unable to effect. This clearly constitutes an act of genocide under the terms of the convention, because the actions taken against me by these federal agents were solely inspired by my presence by act of birth as one of a group of American citizens singled out for punitive actions and eventually extermination by said federal agents as part of the federal goal to commit genocide against any racial grouping. The Genocide Convention was actually drafted after World War II to protect Zionists and Zionists only. It has never been invoked for any other group. The Zionists sought to use it to punish, outlaw, and exterminate all their present and potential enemies, which encompasses all other groups in the world. However, the language of the convention could not be written especially to limit to Zionist conspirators, thereby opening the door for anyone to invoke it in protection of other groups. In December of 1948, the United States advised the Convention on the Prevention and Punishment of the Crime of Genocide, the resultant legislation then being sent by President Truman to the Senate for ratification in the Senate. Senator Percy of Illinois led the fight to ratify the Genocide Convention. Hearings were held in 1950, 1970, 71, 77, and 81. It was officially ratified by the American Bar Association in 1976. The British Parliament ratified it in the Genocide Act of 1969, and Canada then followed suit. Act 2 of the Act states that in the present convention, genocide means in any of the following acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such, killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about physical destruction in whole or in part, imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. The last provision was designed solely to bring about the recovery of any Jewish children adopted by Gentile families during World War II to save them, Section 3 being intended to force these families to return the children to the Jewish group. However, the other four provisions of the Act do apply to the present writer's experience, as documented in a writ for martyrs, which reproduces 120 pages of my FBI files, which established by official government documents that said acts of genocide were committed against my person. The Genocide Convention states unequivocally that intent to destroy any part of the group, that is, any single member of the group, is the same as the intent to destroy the entire group. Thus, Section D is proven by government documents in my case, as are Section A, B, and C. The term genocide was coined by a Zionist propagandist named Raphael Lemkin, that's Lemkin, who intended in his book Axis Rule in Occupied Europe that genocide should be used solely as a term referred to conditions of Jews under Nazi occupation during the Second World War. Thus, it could have no application to any other racial group and theoretically would no longer be valid at the conclusion of this war. It was a temporary destination for a specific historical situation and was never intended to be applied for anyone else's benefit. Zionist collaborators in Crystal all over the world then conceived the idea of a worldwide prohibition against genocide, which was intended to stifle any criticism of their subversive activities and to enact dictatorial measures to eliminate any further criticism, because no nation could possibly enact a measure which stated it was solely to protect Zionism. The wording had to be broadened to apply to all people. It now covers any groups whose future existence is threatened by genocidal government measures, the most threatening target today being the middle-class citizens of the United States who have yet undertaken no measures in their self-defense. As it was ratified by the United States, Genocide Convention states, whoever being a national of the United States or otherwise under the jurisdiction of the United States, willfully without justifiable cause, commits within or without the territory of the United States in time of peace or in time of war, any of the following acts with the intent to destroy by means of the commission of that act or with the intent to carry out a plot to destroy the whole or substantial part of the national, ethical, or racial or religious groups shall be guilty of genocide. Note that the act established jurisdiction throughout the world within or without the territory of the United States, thus extending the authority of the District of Columbia to the entire world. The American Journal of International Law notes that substantial questions were raised about implementing legislation. However, a complaint charging genocide can be charged in any federal court. Thus, question of implementation can then be addressed. In recent years, there have been increasing charges that the personal involvement of judges in the cases which they are hearing, the classical dilemma of conflict of interest, are being ignored. The Wall Street Journal noted August 3, 1988, that a federal judge refused to disqualify himself in an important patent case against Hewlett Packard, even though his son is employed by the computer giant. The suit involved patent rights had been bought by Apple Computer against Hewlett Packard. A case involving much greater stakes surfaced when the investment firm of Drexler, Burnham, and Lambert requested that Judge Milton Pollitt remove himself from the trial of securities frauds which originated with the SEC. It's Wall Street Journal, October 8, 1988. Drexler alerts that Judge Pollitt would be unable to rule impartially because his wife, Mozella Pollitt, stood to gain about $30 million from a leverage buyout of her family firm, that is Palace, P-A-L-A-I-S, Palace Royal, which Drexler was financing. They claimed that Judge Pollack might be biased as a result of his family interests. Mrs. Pollack was selling her inherited interest into Bain and Company, with Drexel placing the securities. A feature article in the American Lawyer, the trade publication, that is, disclosed that Drexel dreaded an appearance before Judge Pollack because of his reputation as overwhelmingly pro-government, as are practically all judges in the United States, with the exception of ill-fated Judge Claiborne. American Lawyer quoted the description of Judge Pollack as a prosecutor favorite judge who conducts a kangaroo court. The article went on to say he chooses sides early. Pollack almost always chooses the government side. Once he does, even-handedness all but vanishes. There is an account of Pollack's calling in U.S. attorneys and discussing pending cases with them, or parts, that is, ex parte, which is strictly forbidden by law. Again, you're advising them on how to handle the case. Does anyone consider this impartiality? The fasting American lawyers' critique continues. Pollack is known as a judge who holds grudges. His wife, Mozella, will gain $30 million if Bain Venture Capital of Boston buys Palace Royal from Mrs. Pollack, who, under the law of judicial conflict, is considered to be the same person as her husband. After Drexel filed a writ of mandamus requesting that Pollack disqualify himself, the Security Exchange Commission launched a vicious smear attack against Drexel's lawyers, in which they strongly defended Judge Pollack. In so many words, the government agency stated, "We want this judge because he is our judge." Likewise, Drexel wanted Pollack off the case because of his reputation as a government judge. American Lawyer concluded, the system will have been disgraced by the charade played out in this case, in which government lawyers have smeared other lawyers, misstating the facts, taking legal positions on judicial conflicts, falling all over themselves to hang on to a judge who promised to provide anything but the justice these lawyers are being paid for. Realizing that their ship had been sunk at the dock, hold on a second here. Realizing that their ship had been sunk at the dock, Drexel gave up any hope of impartial trial under Pollack and caved in. Wow. Agreeing to pay some $650 million in fines and penalties, which probably had been the goal of the SEC all along. To force Drexel into payment without trial, knowing that they could not win before Judge Pollack. The Wall Street Journal ran another front page story about another famous federal judge, that is, on February 16, 1989, hot-tempered 79-year-old David Edelstein, E-D-E-L-S-T-I-N, presided over the federal government's landmark case against IBM in the 1970s. IBM lawyers were the formidable firm of Cravath, C-R-A-V-A-T-H, Swan, S-W-A-I-N-E, and more. The journey took note of the enemies of the judge, that is, IBM and Mrs. Barr's. The journey took note of the enemies, not enemies, but enemies among the judge, IBM and Mr. Barr, putative New York law firm, Cravath, Swan, and more. The enemies are deep. In the 13-year antitrust case, one of the most bureaucratic legal quagmires ever, Judge Edelstein became famous for raging against Kavalar's lawyers. Cravath twice sought to remove the judge from the antitrust case, a drastic step that rarely succeeds in any court. In fact, a request that a judge remove himself from a case for prejudice in a kamikaze move, that is, because prejudiced judges are the norm in our courts, and is a suicidal move for both the lawyers and his client. Not only does the judge refuse to remove himself, as occurred in this case, but he now has even more reason for his deeply rooted prejudice. Cravath declared in his brief, Judge Edelstein's mind is bent against IBM. No court has ever had before is such a long and consistent record of bias as that of the Judge Edelstein's conduct. Cravath then backed this brief with 2 cartons of documented details and grievances contending that Edelstein, among other things, routinely abuses IBM witnesses, helped the government conduct his cross-examination, and secretly altered the trial transcripts in the earlier antitrust case. Is this bias? Are government judges routinely prejudiced in favor of government and against anyone who dares to question the tyrannical acts of government agencies and their agents? Is the sky blue? And more importantly, does justice exist in the United States? Famed lawyer Jerry Spence replies in his latest book, Absolutely Not. Early in his work, the present writer noted that lawyers and judges routinely conspired to obstruct justice by altering transcripts, deleting documents, and suborning perjury, as IBM has found to its dismay. The Journey notes that Judge Edelstein, a wire New Yorker, has long been considered an irascible and impatient force in the courtroom. Appointed by Harry Truman, he is entering his 38th year on the federal bench. The Journey also notes that judges normally can only be removed for the conduct outside the courtroom. These people have awesome power, completely awesome power. Thus, Justice Eisenstein is one of those justices whom the New Republic pointed out in March 10, 1952, had by Truman's department weakened the federal judicial and lower its prestige. Yet there he is, some 38 years later, one of the Zionist judges whom Truman appointed as part of his re-election compact in 48 to recognize and support the state of Israel. The Masonic Burrell nominated these judges, and Truman routinely appointed them as burden which the entire nation must bear. Eisenstein is merely one of the many florid, celibate and biased judges serving in New York and many other states because of their political fraternal association. The Zionist connection governs their choice because of the overriding Masonic connection. It has long been a truism of New York that the Anti-Defamation League of B'nai B'rith, the terrorist arm of the organization, nominates and passes on all candidates for judgeships in New York and all other metropolitan areas of the United States. So feared is the ADL that no American politician dare do anything which might be interpreted as offensive by its omnipresent and even vigilant agents, who have fastened like leeches onto every aspect of American life. The theory exhibited by most judges in the United States when any citizen appears before them charged with being a tax protester or is affiliated with any group suspecting of patriotism is aroused because the presence of any such American in his court is a direct affront to the Zionist and Masonic affiliation of the judge. In most cases, the American is unaware that he has offended the judge or of the violent prejudice which will be shown against him. He's even more unaware that if he is a non-Mason, he is to be given a short shrift before the court as possible. No force-fed American dares to challenge the ADL domination of our process of judicial selection, which then gives even more routine approval by the selection committee of the ABA, after assurance that the candidate meets with the approval of the ADL. The glittering career of the late Roy Cohn, which meteorically rise, was cut short by AIDS. Contacted from one of his many $500 a night call boys, was based solely on the fact that his father was a prime mover in the New York ADL, and was himself appointed a judge. With this family sponsorship, Roy Cohn could do no wrong, despite his many years of tax evasion, drug use, and sexual promiscuity, none of which ever tainted the unabashed admiration with his friend CIA propaganda William Buckley exhibited for him in the pages of his organ, the National Review. Because the secret bias and behind-the-scenes loyalties created by the conspiratorial affiliates of the ADL and Freemasons have now poisoned the entire jurisdiction system of America, we have become inured to the most despotic acts of our judges. Most of the pernicious influence exercises by the judicial can be traced by the career of Oliver Wendell Holmes, a scheme of the New England banking abolition one world conspirators. Holmes was responsible for the new direction of American jurisprudence, the growth of an iconoclastic liberal movement which challenged the traditional concept of judicial impartiality. Holmes' revolutionary doctrine was expressed when he wrote, "It appears to me that it has not always been sufficiently borne in mind that the same thing may be a consideration or not, as it is dealt with by both parties. Note that this is a direct contradiction of the tradition concept that law is a fixed concept." Holmes is saying that there is no genuine basis for deciding whether anything is legal matter in a consideration or not. This opens the door for all sorts of deviation, as well as making the way clear for the concepts of amity law, the law merchant in which individual rights are no longer of concern. The damaging effects of Holmes' dictum may be seen in the erosion of traditional sanctity of law of contracts. Presser and Swillerton, definite work, Law and American History, states that the classical theory of contract has ended. Other authorities write of the depth of the contract, but how is this possible if the law merchant has been enshrined in our courts? Surely the law of contract is based to the law of merchant, right? Not at all. The law merchant ignores individual rights and responsibilities in favor of dedicated service to the greater influence and the greater power. Any contract can and will be overridden if a party can bring enough money and influence to bear in its support. Holmes also stated that the life of the law has not been logic, it has been experience. This opposes Lord Coke's definition of the law as reason and justified the constant changing court decision. Hold on just a second here. Sorry about that. Let's see where we at here. Okay, of the law as reason and justifies the constant changing court decision about error, in which courts first rule in favor of something and a short time later deny its own precedent by ruling against it. In effect, the rule of law is ended because the concept of the law as a fixed force has been superseded by the Homoousian, that is Oliver Wendell Holmes' doctrine that there are no fixed principles or ethics in law. There's only experience. Heebie-jeebies. Just how I feel. Experience has opened the door for the Pollocks and the Esteins to seize control of our courts, for the principles of the American Revolution to be superseded by the blood-soaked aims of the French Revolution, in which the courts became kangaroo courts for a brief stop on the way to the guillotine, for revolutionary tribunals to try Americans not for any legal offense, but because they had opposed the dictatorship of the Committee of Public Safety. Jacques Bainville had written that to write an exact history of the Third Republic of France, it would be necessary to know the official minutes of the Masonic assemblies. This necessity also applies to the history of such organizations as the League of Nations and its predecessor, present-day successor, the United Nations. M. Leon de Pontius published a full review of the Corps of Freemason Congress of the Allied and neutral countries, which were held in Paris on June 28th through the 30th, 1917, which resulted in the League of Nations proposal being inserted in Blanche into the conditions of peace agreement upon the Versailles Peace Conference. A director of a great New York bank was asked how it's possible for high finances to protect Bolshevikism, a system hostile to that movable property whose existence is necessary to the banking industry, and also to those riches which are represented by land and building, not less a necessity for banks. The banker replied, "Those who are astonished at our alliance with the Soviet forget that the nation of Israel is the most nationalist of all people, for it is the most ancient, the most united, and the most exclusive. But its eyes are turned to the future rather than to the past, and its kingdom is not of this world." First comes this sentence, like the papacy, it is ecumenical and spiritual. But then you will say that Marxism is the antithesis of capitalism, which is equally sacred to us. It is precisely for this reason that they are direct opposites to one another, that this puts into our hands the two poles of the planet and allows us to be its axis. We are kings that the prophecies may be fulfilled, and we are prophets that we may not cease to be kings. They take us for birds of prey, but we are carrion birds. Israel is the microcosm and the germ of the city of the future. The arrogance of our judges stems from the assurance that they represent a higher power than their lawful government of the United States. No wonder they sneer at the Constitution and revile any citizen who comes before them, citing the protection of the Constitution. The Masonic arrogance of these judges is epitomized by the name of Judge Irwin Cooper. Time magazine noted March 30th, 1962, that Congressman Manny Seller, whose political career reeked with corruption and double dealing, has sent the name of his old friend and ally, Judge Irving Cooper, that is the ADL approved, as federal judge for the prestigious South Side District of New York. Cooper had been born in London, the son of Max and Ruth Shemansky. Seller anticipated an easy confirmation of his friend and was stunned when many witnesses came in to give page after page of damning testimony against him. One witness testified that when she used the word "we" in her testimony before Judge Cooper, he screamed "we," about 5 times, meaning that I had dared to put myself in his class. How dare you say we? Then he started to rave. His eyes started popping. His face turned purple. He looked like a reincarnation of the devil or something. Many other witnesses testified that Judge Cooper excoriated, publicly humiliated lawyers and others who appeared before him. He turned his back on us and berated the group. Many other potential witnesses feared to testify about his notorious behavior for good reason. Despite his overwhelming testimony against him, Cooper was unanimously confirmed as a federal judge. 25 years later, Who's Who still lists him as the federal judge for the Southern District of New York. The fact that a judge could win confirmation after such damaging testimony is proof that the Masonic influence overrides all other considerations in naming a judge to the bench. The press has carried hundreds of stories about apophylae, cursing, and obscene judges who abuse anyone unfortunately enough to come into their court, but nothing is done. There is the constant fear engendering in their subjects by these tyrannical judges. There is the myth of judicial immunity, which has no constitutional basis, and most important of all, there is this terrible hidden Masonic power behind the bench. The stranglehold which Benoit Barai maintains over our courts leads to extreme financial abuses, a continual extending of bribes, favors, and undue influence which the practitioners of the will of Canaan exercise against all who come before them. The New York State Chamber of Commerce analyzed, saying 3,500 foreclosure cases and found that 75% of the receivers who were paid fees of over $2,500 were either active political workers or personal friends or relatives of the judge. This is based upon Reader's Digest in November 1948. Now, folks, this is 1948. Let's fast forward here a little while, okay? So 98 would be 50 years. 2000 would be 60. 2018 would be 70 years. So has it gotten any better? I don't think so. Of the courts which produce a steady stream of revenue for its inmates, none is more notorious than the probate courts, of which the king is the notorious suffragette court of Suffolk, New York. The scene of many historical family battles, this court probates the wills of the nation's wealthiest families. The fees run into the hundreds of millions of dollars. This writer attended sessions in this court concerning a will which the lawyer prolonged over 8 years, merely because he wished to maintain the case in his books. At these conferences, I was often supposed to be an attorney and was taken aside by attorneys for some of the nation's largest firms who dedicated hinted they would appreciate any help I could offer in bringing the case to a conclusion. I could hardly admit that we maintained the case so that we would have an excuse for daily drives to the beach, a much less sinister reason than the determination of most lawyers to squeeze the last dollar from their clients. When one enters a notorious court such as the Suffolk probate, one can only smile at Plato's naive statement, justice is the supreme virtue, which harmonizes with all other virtues. The administration of justice in America warns us that the most idealized system can in short term become a nightmare. Jeremy Bentham announced the most grinding of all grievances, the tyranny of judge-made laws. The outcries of the people against legal abuses resounds throughout history. Magna Carta XIV promises that we will not make any justicials, constables, sheriffs, or bailiffs, but from those who understand the law of the realm and are well disposed to observe it. Amos 5:7 criticizes those who abuse the process, ye who turn judgments into wormwood. One of the underlying causes of the French Revolution was the flurry of lawsuits, dragging on for generation after generation and impoverishing everyone but the lawyers. At last, the people exchanged these oppressive courts for the summary justice of the revolutionary tribunals. Dickens was moved to write about the terrible ordeal endured by Englishmen, embroiled in lawsuits for many generations in his famous case of Jardice versus Jardice, which was based on an actual occurrence in English courts, although Dickens' rendition of the behavior of lawyers and justice was written as satire. It can be observed in any American court today. Lord Campbell complained in his Lives of the Chief Justice of the 18th century that the bench was occupied by legal monks, utterly ignorant of human nature and of the affairs of men. Decisions of these legal monks show not so much ignorance of human nature as unaudible opposition to it, because their decisions are dictated by their secret allegiance and their hidden agenda. You see, this all hooked up with many secret clubs and groups, you see. As a respected American judge, Judge Learned Hand was never nominated for a seat in the Supreme Court, despite the general acknowledgement that he was our most distinguished jurist. In his memoirs, 50 Years of Service, he said, I confess when I look at my service, it seems to have been for the most part trivial. As a litigant, I should dread a lawsuit beyond among anything else short of sickness or death. This was a speech that was done in August 10, 1959, U.S. Court of Appeals. Judge Samuel Rosman, former advisor to President Roosevelt, told the bar of the city of New York, October 1964, let us face this sad fact that in many and far too many instances, the benches of our courts in the United States are occupied by mediocrity, men of small talent, undistinguished in performance, technically deficient, and inept. Yet these are the men who continue to serve on the bench because no one can remove them. See, this was the fallacy of the Constitution, folks. See, it gave the judges the right; they could not basically be thrown out. Almost impossible. Chief Justice Arthur Vanderbilt of New Jersey said in the 8 centuries or more in which the judicial office has evolved in the Anglo-American system of law, 3 essentials stand out in the definition of a true judge. These are impartiality, independence, and immunity. In 1961 Handbook for Judges, American Juridical Society in Chicago cites JUD Canon 3. It is the duty of all judges in the United States to support the federal Constitution and that of the state whose laws they administer. In so doing, they should fearlessly observe and apply fundamental limitations and guarantees. This canon contrasts sharply with the conduct of judges whose fury is aroused by citizen pleading his constitutional rights. Judicial Canon 4 states a judge should not allow his name to be used for solicitation and charitable contribution. This is the most abuse of judicial canons. Not only do judges constantly solicit, that is a synonym for prostitution, but they let it be known that a contribution to their favor or charity might well affect their decision in some future litigation. My, oh my, oh my. The most obvious perversion of this canon is the practice of judges to sentence hardened criminals to community service, to work free and charity personal chosen by the judge. This in itself both a solicitation and contribution. A person who is judged guilty of a crime is expected to go to prison, not to become a social worker. Roger McFarland, who was found guilty of a political offense, was sentenced to 200 hours of community service. Oliver North, also a political offender, was sentenced to 1,500 hours of such a service. The idiocy of this arrangement was lampooned by Ezra Pound more than 50 years ago in his book called A Guide to Culture, Kulchur. The imbecility of America from 19 onwards was lost of all sense of borderlines between public and private affairs. The eradication of this line is a crucial goal of the Marxist state. As earlier conditioned by Pound in his magazine, The Exile stated, the republic, that is res publicae, means or ought to mean the public convenience. When it does not, it is a evil to be eliminated or amended out of, or into decent existence. This definition of the republic should strike terror into the hearts of all bureaucrats. The thought of doing something for the public convenience would indeed amend them out of existence. Samuel West, the election sermon, that is 1776, notes, but though I would recommend to all Christians as part of the duty that they owe to magistrates to treat them with proper honor and respect, none can reasonably suppose that I mean that they ought to be flattery in their vices, or honored and careless while they are seeking to undermine and ruin the state. For this would be wickedly betrayed our just rights, and we should be guilty of our own destruction, you see. We ought to persevere with firmness and fortitude in maintaining and contending for all that liberty that the deity had granted us. An ancient legal adage says, blessed are the troublemakers, as even more ancient ones claim that if there is only one lawyer in town, he will starve to death, but let a second one arrive and both will become wealthy. The Spanish proverb says that a peasant between 2 lawyers is like a fish between 2 cats. De Tocqueville stated that in America there are no nobles or literate men, and the people are apt to mistrust the wealthy. The lawyers consequently form the higher political class and the most cultivated portion of society. If I was asked where I placed the American aristocracy, I should reply without hesitation that it is not among the rich, who are united by no common tie, but that is the occupiers of the judicial bench and the bar. This is from his book, Democracy in America. One of the first precepts of the American judge is that he will exercise all of his powers to harass and disqualify the bane of the legal profession. A citizen who refuses to hire a lawyer and who chooses to represent himself in court as his constitutional right. These mavericks appearing as attorneys pro se, or more recently as the impropriated personnel, causes consternation among lawyers and judges. A person who appears as his own lawyer threatens the entire financial operation of our legal system. You bet it does. Let's make a deal. You see, a lawyer cannot make a deal with a layman in litigation because it will scuttle the system. In some 40 years of representing myself, I have encountered every mention from judges ranging from supercilious tolerance to outright hostility. Early on, I was standing outside the judge's chamber when I heard the judge raising his voice for my benefit. You can be sure of one thing, he informed the opposing lawyer. As long as I'm a judge, you will never see a favorable opinion from me for anyone who tries to represent himself in my court. You see how this thing is stacked against you. People need to know the truth, folks. You really need to know the truth. Even though it's hard to bear, you need to know the truth, really. This judge, like his colleagues on the bench, remained true to his resolve. I never obtained equal treatment in his court. He seemed determined to teach me a lesson when I appeared and always was disappointed when I came back for more. One lawyer actually tried to help me when I was still unaware of the legal dodges. I had no idea what was going on when the judge asked me, "Are you going to file a motion, Mr. Mullins?" I didn't know what a motion was, and this lawyer nudged me. "Tell him you filed the motion." I let the opportunity pass. This attorney, who was obviously not cut out for the conspiratory world or legal practice, soon abandoned it for a political career. That is, Philip Stern quotes the edict, a professor of Harvard Law School, when a student questioned the fairness of legal techniques. If you believe in fairness and justice, you should be attending a divinity school. Law professors notify their students that once they have taken legal training, they will never be the same. Their outlook on everything from morals to social life undergoes a complete change as they commit themselves for life to legal monkhood and the cult of the black robe. They have now joined the mystical world of Babylon and have put aside the decencies of normal life and American citizenship for a stranger calling. Both Philip Stern and Professor Fred Rodell of Yale University agreed that the person acting as a pro per has little chance of ever having his case actually tried by a jury. Rule 7, Section 2, U.S. Appellate Court states, briefs not signed by counsel who are members of the bar of this court and fully qualified under the provisions of this rule will not be considered by this court. When I filed an appeal with the U.S. Court of Appeals, the decision proved that it had not even been read by the judges. A law clerk had probably notified them that it didn't qualify, and they signed a pro forma denial of the appeal. Folks, there's no justice here, you see. It's a den of thieves. In 1977, Chief Justice Burger issued an order that the U.S. Judicial should not accept cases where the plaintiff had no legal standing under the rules of court. This is all a club, you see. The judge has two effective weapons against persons appearing as attorneys pro se. He can award attorney fees against them, which can be ruinous, or he can invoke Rule 11, which sets up a number of conditions that a pleading be well grounded in fact, warned by existing law and other factors, which give the judge enormous leeway in invoking Rule 11 against persons representing themselves. U.S. District Judge Richard L. Williams invoked Rule 11 against a retired professor, J. Carl Pondexter, assessing him $11,202 for bringing a case against Virginia official on a tax matter. Pondexter termed the sanctions Soviet-style oppression, particularly when government defendants are granted attorneys fees from citizens bringing in civil rights action. He stated Rule 11 violates the most essential of all civil rights, the right to enforce one's civil rights through free access to the courts. If lawyers are intimidated by this threat, they will not take any case from civil rights defenders if there is a chance of their being sanctioned. The The present writer sued a city and county for violation of jury selection rules, which was dismissed in federal court without even argument. But not before the government attorneys had leaped to this feat 3 times, shouting for attorney's fees. In this case, they would have announced to some $25,000, a sum which I did not have. The judge refused to grant attorney fees because he had not adjudicated the case and ran the risk of reversal if I appealed, as I would forced to do rather than pay $25,000, which I did not have. Charles Ashman, excellent works, the finest judges money can buy, cites hundreds of pages of documented corruption among judges, beginning with Sir Francis Bacon's statement while Lord Chancellor of England. I usually accept bribes from both sides so that the tainted money can never influence my decision. That tells you a little bit about who Francis Bacon is, isn't it? Deuteronomy states that thou shalt not respect persons, neither take a gift, for a gift doth blind the eyes of the wise and reverse the words of the righteous. On June 11, 1973, the California Judicial Qualifications Commission recommended only censure of 2 Los Angeles judges who have issued numerous blank pre-signed releases forms to bondsman friends. Judge Mitchell Schweisler, who served 26 years in the Court of General Sessions with the support of both the Democratic and Liberal parties, was described in these words. Some lawyers regarded Schweisler court as a circus. The judge shouts and he snorts and he huffs and puffs and he conjures frightened lawyers and their clients to cop pleas to save time, but I must admit it's entertaining. And Congress fixer Nathan Bolshin used Speaker of the House Judge John McCormack's office as his private headquarters to fix income tax cases. Dr. Irvin Hepler, a Dayton urologist, gave him $300,000 to fix a case and never heard from him again. Hepler was convicted and fined. After Fortes graduated from Yale, no, wait, let's stop. Whoa. Dr. Irving Hepler, a Dayton urologist, gave him $300,000 to fix a case and never heard from him again. Hepler was convicted and fined. A. Fortes, graduate from Yale Law School, and became the protege of FDR's cabinet member Harold Ickes, I-C-K-E-S, who appointed Fortes Undersecretary of the Interior. Fortes later became the confidant of Lyndon B. Johnson, represented him in the senatorial primary case where Johnson had been ordered off the ballot. Fortes saved Johnson's political career by winning the case, making possible Johnson's later ascension to the presidency. As President Johnson named Fortes to replace Arthur Goldberg on the traditional Jewish seat on the Supreme Court. Fortes, who was to be named Chief Justice, accepted $15,000 from Troy Post to lecture at American University and then became involved with wheeler dealer Louis Wolfson, who paid Fortes $20,000 and put him on a life retainer of $20,000 a year. On May 14, 1969, Fortes resigned from the Supreme Court. Justice William Douglas of the Supreme Court married his 4th wife at the age of 66 after his 3rd wife divorced him. Congressman Gross prepared articles of impeachment against Douglas, who was being paid $12,000 a year from the Parvin Foundation, a $3 million foundation set up by Parvin when he sold the mob-connected Flamingo Hotel in Las Vegas. Parvin has been named as a co-conspirator with Louis Wolfson. Congressman Gerald Ford also called for Douglas' impeachment after he wrote an article for the Evergreen Review, which appeared in an issue of the magazine replete with pornography, photos, and articles. Unlike the earlier case of Sir Francis Bacon, Douglas was never impeached. Bacon was impeached after evidence that he had taken some 12,230 pounds in bribes, with 28 charges against him. Judgment was that Lord Chancellor had given way too great exaction by his servants, both in respect of private seals and otherwise for selling of injunctions. The invokings of Rule 11 by federal judges is intent to seal off the courts from redress by private citizens and to allow them their secret aristocracy with its hidden agenda to continue its practice of bribery and other corruption. The Sanders Spooner wrote in 1952, I think that's supposed to be 1852, it's an error there. The legal effect of these constitutional recognition of the rights of individuals to defend their property, liberties, and lives against the government is to legalize resistance to all injustice and oppression. of every name and nature whatever on the part of government, but for the right and resistance on the part of the people. All government would become tyrannical to a degree of which few people are aware. Constitutionals are utterly worthless to restrain the tyranny of governments unless it be understood that the people's will, by force, compel the government to keep within the Constitution limits. Practically speaking, no government knows any limits to its power except the endurance of the people. Tyrants care nothing for discussion that are to end only in discussion. Discussions which do not interfere with the enforcement of their laws are but idle wind to them. Suffrage is equally powerless and unreliable. I would recommend anyone who would like to read some good stuff would be Lysander Spooner. That is a quote from him. A brilliant man. He's written quite a few little, and he was to the point, folks. He never played games. So that's the end of chapter 4 tonight. And it's about time for me to go to bed. It's a lot longer than I anticipated tonight. Again, this is by The Rape of Justice by Eustace Mullins. And it's about the longest video I've ever done. It's almost 2 hours. I want to get the chapter done, that is, chapter 4. I thought it's important to do that. Get it out there for others to see so that they can begin to read it. Again, these books are, I think they're approximately about $25 a piece. They're in paperback form, although the hardback ones are more expensive, if you can get them, that is. You're lucky even to find them in paperback. But I'm going to say goodnight and wish everyone well. Thank you for being here again. Please share this with others. It's important for us to understand this information. It's a warning because we live in a very dark time, folks. Seriously. And so I hope that you glean from what is being shared and you'll share it with others. And that's pretty much it. Probably need to go to bed. So have a good night. Take care. Again, thank you for listening. Take care. Bye-bye.